I'll call this council meeting to order. Roll call.
Mayor Yanish.
Here.
Councilmember Anderson.
Here.
Christensen.
Here.
Amon.
Here.
Nelson.
Here.
Johnson. Dockin.
Here.
Baggerly.
Here.
DeBleek.
Here.
8 present, 1 absent.
Would you all please stand as we say the Pledge of Allegiance? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have any additions or deletions to the agenda? I have one I'd like to, under miscellaneous, I'd like to make an announcement. And consent items.
Move to approve.
Second. Councilman Dockin.
Yeah, I'd like to pull the MUC minutes, building inspection report, and community activity center council minutes. Just briefly.
Does that need a second?
It does.
No.
Do we need
If you're just going to comment on them, I think if you're just going to comment on them and discuss them, you can do that as part of the motion and then approve them. If you want to remove them from the consent agenda, then that is a motion and a second.
Well, I'll second it. I mean,
We want to remove the
We don't need to. That's good.
building inspection report.
Item C, G, and H, Mr. Mayor.
C, G, and H. Okay, we'll remove those items from the consent items and approve. Do we have a motion to approve the other items?
We did.
Yes, sir, we have that.
All those in favor say aye.
Aye.
Those
Aye.
opposed say no. Councilman Dockin.
Thank you, Mr. Mayor. I attended Councilmember DeBleek was off at a conference for the MUC. Anyway, this is the March 5th MUC Utility Planning Committee minutes. And item 3 talks about district heating credit as a result of pre-established calculations following the 2011 and 12 heating seasons. MUC collected more funds than required for the heating season. MUC is currently in possession of extra funds, approximately $34,000, that we are proposing to refund back to our heating customers. Refunds will be distributed back as a credit to the heating customers based on their usage. And I thought that was interesting. So I'll move to, unless there are questions, to file these minutes.
second.
Motion has been made and seconded to file the minutes of the Municipal Utilities Committee minutes. All those in favor say aye.
Aye.
Those opposed say no.
And then the building inspection report indicates that that Rice Home Medical is doing a $527,000 interior remodel, and they do in fact pay fees, and the fees that they paid were $5,216.80. So Rice Home Medical is not one of those that is part of the payment in lieu of taxes, and I'd move to file those minutes.
Second.
Motion has been made and seconded to file the minutes of the building inspection report for February 28th. All those is there any discussion?
Mr. Mayor,
Yes.
Councilman?
I need clarification from staff. I think that they do include, am I wrong, that the Rice Home Medical is included in their calculation? It is included in their calculation for payment in lieu of taxes, their net assets?
It is in their financial statement in the total net assets. That's
okay. I just want to clarify that.
The fee that they pay would be for their remodel and such, and that's separate from their payment in lieu of taxes.
Okay. Didn't know that.
Any further discussion? All those in favor say aye.
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 Those opposed say no. That motion carries.
And then the Willmar Community and Activity Center, item 3, they talk in here about the maintenance and finance report. There were there were 82 rentals, which included 2 weekend rentals, and 16 before after regular hours, which is right on track with last year's number. The 2013 rental contracts have been sent out, and only one group has questioned the rent increase. A question came up on the status of service master contract. The city office is still working on the cleaning concerns. And I know that that was, when I was the liaison out, that was a continuing problem out there, is getting service master to clean properly. And one of the suggestions that I made was that if they don't do something and they say that they did it, why are we not deducting it from their payment? I think we need to look at that, you know. In other words, when they clean out there and we're going to pay them and they're not cleaning, why would we pay them? Why would we not deduct that and get their attention? And I would request an answer to that.
Staff is working to resolve the issues with the service master contract. We have had issues with the service master vendor at the community center and at other facilities, and staff is working to resolve those and look at what the alternatives are.
Yeah.
Thank you.
But I would guess that an alternative would be that the contract would allow us to deduct if they're not doing what they say that they will do for us on a contract.
Is that one of the things, Charlene?
That is an option that we are exploring, yes.
Okay. Thank you. I'd move to file the minutes of the Community Activity Center Council minutes.
Second.
A motion has been made and seconded to file the Community Activity Center Council minutes. Is there any further discussion? All those in favor say aye.
Aye.
Those opposed say no. That motion carries. Are there anyone scheduled to talk, Kevin?
No, sir.
Okay, we'll move on to, the presentation of the downtown plan. Albert Anderson decided that the weather was prohibitive, so he did not come from the Twin Cities area, so we will skip to the presentation of the open meeting law with Mr. Scott.
Good evening, Mayor and members of the City Council. It's Sunshine Week this week, which has nothing to do with the weather outside, obviously. What it is an effort by many good government organizations to draw attention to their efforts to promote transparency and openness in government. So the timing is good for this as well, because you have a lighter agenda today. And in light of your swearing in of your newest council member last month, it seemed like a good time for me to come today and provide a refresher to the City Council on some of the issues with the Minnesota Open Meeting Law and the Minnesota Government Data Practices Act. I've included in your memorandum, or excuse me, in your packet for today, a memorandum from my office, just kind of outlining some of the issues and some of the requirements of these laws. The laws are kind of referred to typically as sunshine laws. Their intent overall, above everything else, is to shine a light on government, to establish presumptions that actions of the government body be taken in public, and that the data governments generate and receive generally be public, both in the context of meetings and with the information you receive. There's important exceptions to those general presumptions, but the overarching purpose of both of these laws, the Open Meeting Law and the Data Practices Act, is to promote transparency in government and to make things public. So as I mentioned, there's a memorandum in your packet. It highlights some of the issues with these laws, some of the requirements. The purpose of the memo and of this presentation today, I can assure you, is not to comprehensively address every issue that ever comes up to the point where you're never going to need to ask questions about these laws. The intent is to just give you a familiarity with what these laws do, what their purpose is, what some of the particular issues that tend to come up most frequently are, and to just simply raise your awareness so that you're cognizant when some of the stickier issues come up that could lead to, for example, a violation of the Open Meeting Law or the Data Practices Act, and you can steer away from those or seek assistance from staff or from my office as necessary. Attached to the memorandum, I've got a printout of the 2 PowerPoint presentations I have. I'm going to meld into one for you today. What you have is a little more thorough than what I'm going to do today. And again, that's intended just to give you a resource that you can look back on if you have a sticky situation come up and you're not sure how to handle it. You can look at that first. You'll notice on a lot of these slides the recommendation is to ask your city administrator or your city attorney, because these are complicated issues. Again, the intent here is that you're just going to have a bit more familiarity, a bit more awareness of where potential violations are, how to avoid them, when you need to get a little assistance. So with that, we'll start with the open meeting law. As I mentioned, it's a sunshine law. It establishes a presumption that all meetings of a public body have to happen in public. It does 2 basic things. It requires that adequate notice of all public meetings be given so that members of the public who want to observe have that opportunity. And it requires that the members who do choose to attend those meetings be allowed to observe the public body as they conduct the city's business. And again, the purpose of it is to protect the public's right to be informed of the decisions that its governing body is making, to give it the opportunity to be present and to observe its government body in action, and to prohibit the city council, any local government body, from conducting meetings in private. That's the general rule. As we'll talk about a little later, there are specific exceptions to the open meeting law. I think for the most part, most of you have been involved in closed sessions before, so there are specific exceptions carved out of the general rule, but generally, any meeting of the public body has to be open to the public and properly noticed. A couple things the open meeting law does not require that a lot of people frequently assume it does. It doesn't require notice of regular meetings to be posted. Regular meetings, you've got a designated time, in your case the first and third Mondays, as long as you meet when scheduled. You're supposed to maintain a schedule of when those regular meetings are, as long as you are meeting when your schedule says you'll meet. There's no special notice required for those. It doesn't require any specific parliamentary procedure be followed, although now your charter does. And it doesn't require the public to have an opportunity to speak. And I know that your practice is to have an open forum, and that's perfectly fine. It's not a requirement of the open meeting law, however. There are certain issues you'll consider, and certain statutes apply to various actions that you can take that would require a public hearing that does guarantee the public's right to give testimony on that issue. But those are on specific issues. In general, there is no right of the public to speak to you at a public meeting. Their right is to attend and observe. There's 3 issues that come up most often when our office is called on to interpret and apply the open meeting law to various situations that arise. And the questions are created by some ambiguities in the law. The first question is, what is a public body? The second one is, of those public bodies, which ones are subject to the open meeting law? And finally, this is the third one up here is the one that I'll talk the most about. It has the most, it's the easiest to cause problems for bodies, and that is what constitutes a meeting of the public body. In your case, it's pretty clear. You're a city council. You're absolutely governed by the open meeting law, as are all your boards and commissions, the Rice Hospital Board, the Utilities Commission, your Planning Commission, all the commissions that are affiliated with your government that were created by charter or by ordinance have to comply with the open meeting law. In the case of the hospital, there's some more specific issues and specific laws that allow them to do some things a little bit differently. But clearly, as a body, the city council is governed by the open meeting law and has to comply with it. It does not extend to any private organizations that you might have some contacts with or contracts with or might fund in some way. Those organizations are private and they're limited ties to the city does not bring them within the scope of the open meeting law. And that's true also of the other laws I'll address. There are some circumstances where it's possible that there could be a body that is, by all respects, public in nature, but would nonetheless not be required to comply with the open meeting law. That would be the case if you have an ad hoc committee of less than a quorum that meets as needed on a specific issue. That does not include your standing committees. You have 4 standing committees with chairmen that meet on a fairly regular basis. Like those would clearly be covered by the open meeting law. However, it's possible that if, for example, you need to negotiate a contract and you want to appoint a negotiating committee, and you decide it would be helpful to have 2 or 3 members of the city council on the negotiating team. That group, assuming all these requirements are met, is not going to be subject to the open meeting law. And those requirements are that obviously it can't contain a quorum of the city council. It can only have the power to recommend, so it can negotiate terms with this group, but it can't bind the city on its own. It would have to bring its recommendation back to the full council for action. And it has to be a non-standing committee. It would meet only as needed, and when its issue is resolved, it would not need to meet anymore. As I mentioned, that's a distinct situation from your standing committees. Those seem pretty clearly to be subject to the open meeting law, and they are, I'm aware, operating as if they are subject to the open meeting law. Our recommendation with all committees that the city council establishes is that you take one of 2 tracks. One is, if it is more of a formal standing committee, as your 4 standing committees are, that you just follow the open meeting law as if it were the city council. If it wants to meet at a time other than a time on its meeting schedule of regular meetings, it would need to notice it as a special meeting, just as the city council would, and observe all other requirements of the law that we're going to be going through. To the extent you do ever have an ad hoc committee that would not otherwise be subject to the law, the way to make sure you don't accidentally kind of get too close to the line and have an issue about whether that committee is met in violation of the law is to make sure that, again, it meets only as needed, that it does not involve a quorum of the public body, and to overall observe as few formalities as possible. If you have an ad hoc negotiating committee, don't have it make formal minutes and submit them. You can have someone attend the city council meeting and give a report, that's fine, but the fewer formalities, the better, if that is not otherwise following the procedures in the open meeting law. I meant to say at the start of this presentation, if you have any questions, feel free to interrupt. These presentations go sometimes better when it's interactive, and if you have a question that comes up on something I said, feel free to jump in.
I do have a question. I don't know if it pertains to what we're talking about yet, but if we have something that requires a 5-4 vote, or I'm sorry, a 5-3 vote, would the mayor's, it ends up being a 4-4 tie on the vote, does the mayor break that tie? Does his vote count as a 5-4 vote?
Yes, that's a matter that's governed by the city's charter. The charter establishes that the mayor does not vote except in the case of a tie. Is that what you're referring to?
That's what I'm referring to,
yeah.
Right.
So that's not an open meeting law issue as much as just how the charter is set up, how the structure of your city government works, but that is correct.
So if it's something that requires a 5-3 vote, then it's a 4-4 tie vote, the mayor's vote would count and make it the fifth vote?
I'm sorry.
Not entirely if you're thinking ordinances, because the charter controls ordinance by 5 affirmative votes, as in improvement orders are 7 affirmative votes. So the mayor can't be involved in either of those. That tie-breaking activity is for standard motions.
Right, only when it's 4-4.
Okay.
So if there's a other majority requirement, or even if it's just a 5 vote, no matter how many are present, in that case, the tie-breaking procedure in the charter wouldn't apply.
Okay, thank you.
I do have a question, Mr. Mayor, if I may.
Go right ahead.
A couple of them. We see the word quorum all over. I mean, what is a quorum of this council? Is it 5?
members.
5.
Correct.
So 4 can meet anytime as an ad hoc committee somewhere.
Correct, subject to a lot of other cautionary notes that I'm going to sound here as we proceed through the presentation. But yes, a meeting of less than a quorum of the council, so 4 or less, is not a violation of the open meeting law.
Well, I hear that 3 is a quorum, and I know that it's 4, but I mean, some people don't know that. That's why I wanted it public. 4 is not a quorum. How about a task force? Do they obey the open meeting laws too? I mean, none of the council are on it. Are they subject to that?
It would depend entirely on how it's set up and where it gets its authority.
If the mayor
Depends
formed a
on-
task force, are they subject to it?
It would depend who's appointed to it.
No council members. Most task force don't involve the council.
Okay.
I mean, we have a water or a stormwater task force presently, and none of the council are on it. I mean, do they abide by the open meeting law then, or they're not?
It wouldn't seem to me that that entity would be subject to the open meeting law.
Now one staff person does attend that. When we have an engineer, they usually attend. That doesn't have any bearing on it either then, right?
Yeah. I mean, there's a lot that goes into the inquiry. What is their authority? What are they doing? But if they're not taking action that's going to bind a actual public body, if they're just going to be recommending something to the
Okay,
city
that's
council,
usually a recommendation that they have.
in that case, then no.
Sure.
It wouldn't be.
Another question. Councilman Dockin had a meeting at the KEC during the last campaign, and he invited everybody in his ward to come over. Well, there was people from all over the city that came, but if 5 council people attend that, or Jim and 4 other council people attend it, is that what has to be done there? Is that does he have to put it in the paper as a notice somewhere, or?
If it's, we'll get into some of this stuff, so I don't want to put this off. But basically,
Okay.
if city business is going to be discussed and there's a quorum of the city council there, it would need to be noticed. And if it hadn't been noticed, then there should be no discussion of city business.
Okay, I'll let you continue. Thank you.
And this gets into some of the questions, Councilmember Christensen, you were asking. The third and kind of the stickiest issue that we have to resolve when we're trying to figure out whether the open meeting law applies in a given situation is, what is a meeting? And this is the one that gives city councils and other entities some of the most difficulty, because it's not always intuitive what constitutes a meeting. And it's not defined in the open meeting law, so it's a matter of interpretation. There was a case from 1983 that essentially established the rule: a meeting of a public body is any meeting in which a quorum or more of that public body is present, which generally means a majority, and at which public business is discussed. If those 2 criteria are met, then it's a meeting that has to be noticed according to the provisions of the open meeting law. There's some issues that come up, and I think you hinted at some of these. What about a social gathering where it's likely, or it just happens, that a majority of the city council attends? What about communicating immediately before or immediately after a meeting that was otherwise noticed properly, but outside the actual window when the meeting's taking place? How about joint meetings with other public bodies, or serial meetings? And serial meetings are particularly challenging because in those cases you don't have any one moment where you have a majority of or a quorum of the city council present, but as we'll see in a minute, that can still nonetheless create some issues. And the biggest part and the biggest problem with that is electronic communications. Can you, in fact, violate the open meeting law by discussing city business in email or on a blog post, or some of the many ways that people communicate nowadays that didn't exist when the Supreme Court decision that set forth this rule was issued in 1983. Regarding social gatherings, the general rule is, as long as no public business, no city business is discussed, it's not a violation of the open meeting law for a majority, for a quorum to attend. If city business is discussed, even if that wasn't the main point of the meeting, then that very well could be a violation. The best advice we give on this, the best practice we recommend city councils follow, if there's an event coming up that you know is likely to draw a majority of the city council, you might as well just go ahead and notice the city council's attendance as a special meeting. Be liberal with what meetings you notice. In that case, you're protected no matter what anyone says or what someone alleges they overheard isn't going to create any issues because you've noticed that the meeting is going to take place and anyone that wanted to could be there and observe it. It's probably unavoidable that there will be some occasions where a quorum or more of you are present and it wasn't anticipated. When that happens, just be aware of it. And remember, don't discuss city business at those other events, social events, whatever they might be. Again, this is just something that we've seen that cause issues in other cities, and we thought we'd highlight it, increase your awareness so that if the situation does arise, you'll have something to draw on. The other issue, before and after meetings, seems a bit nitpicky, but if a quorum or more is discussing city business, either in anticipation of the meeting or because they just had more to say after a meeting, that has been held in the past to be a violation of the open meeting law. Just want to highlight that for you. It's obvious, the temptation is obvious and understandable when the quorum is not together in the same place very often. It's easy to jump the gun a little bit. It's easy to want to sort through some issues to allow the meeting to go smoother. This doesn't mean you can't talk to one or two other council members, but be very mindful not to allow a discussion to include the quorum of the city council. Our recommended best practice is that you generally avoid discussions either before or right after the meeting with other council members, but if it does happen, just make sure it's one-on-one or involving less than a quorum. The issue of serial meetings. This is when, I'll give you the classic example of a serial meeting that's been found to violate the open meeting law. One council member or a mayor there's a controversial issue coming up at the next meeting, and the council member really wants this to pass. So he starts calling up council members one by one and discussing the issue and making the case for it and trying to secure the votes ahead of the meeting. If that happens and it involves more than a quorum of the council combined in any of those meetings, it can be a violation of the open meeting law, even though there was never a moment where a quorum was present in the same place. It nonetheless has been found to circumvent the purposes for which the open meeting law was passed. The Department of Administration that administers this law has issued many opinions that caution serial meetings and do indicate that serial meetings could violate the open meeting law.
Robert?
Yes.
Excuse me. Does the quorum include the mayor?
It's an interesting question the way your council is set up. You have 8 members that vote normally and 9, the mayor I think is a member of the city council. So I would say the answer is yes, even though it's a little different with the unique role that the mayor has in Willmar. But yes, the mayor is part of the city council. It's a 9-member council. A quorum is 5. So I would say a mayor and 4 other council members would be a quorum.
Okay, thank you.
Regarding serial meetings, the largest area or the largest source of calls that we field and requests for opinions is in the area of electronic communications, specifically emails, but it can be blog posts, it can be comment sections of newspapers, many different forums where people communicate today. And essentially, even this is a little different than the classic example of a serial meeting I just gave you, but the effect can be exactly the same if there are conversations between individual council members or a small group of council members that then spill over into follow-up conversations with additional council members, or even if there's 1 or 2 replies to a quorum or more of the city council, that raises issues the same as a serial meeting would. Has a quorum of the city council just conducted business outside of a public meeting where the public can't observe it? I have had occasion to correspond with the full city council, and you'll notice that when I do it, it's addressed to myself, and then you won't see yourselves listed in the to field of the email or in the CC field. And the reason I do that is part of the recommendations that we have for the council and for staff who communicate with the council is to list the council members' email addresses if an email has to be sent in the blind copy field. The reason for doing that is if anyone has an inclination to reply to the message and they hit reply to all, they don't accidentally just raise an issue about whether a serial meeting occurred by replying to the full city council on a matter of city business. So that's our recommendation. If emails do need to be sent, and sometimes they will, just to transmit information efficiently, that's how you address it if it has to go to the mayor and full council. The other pieces of information here and advice would be try and keep the correspondence on email one way. Like I said, it is necessary on occasion to communicate with the council this way. It's the most efficient way in many cases to get information to you. There's nothing wrong with that at all. And really, there's nothing wrong with one council member doing that as long as precautions are taken to make sure that there's no replies and that this does not evolve into a discussion of an issue over email. So engage in one-way communication, and to the extent possible, avoid emails addressed to a quorum or more of the council. If possible, if one of you has information you would like to share with the council before an upcoming meeting, the best way to do it would be to provide it to staff and have staff send it to the council. And that would be the best practice that we'd recommend you follow. Are there any questions on this one? Because, like I said, this is probably the single issue that generates the most difficulty for different public bodies. And it's because, I'm sorry, go ahead.
Well, I talked to you earlier this afternoon about a meeting, let's say, to discuss issues coming up in the city, like a weekly meeting with the mayor and 3 council people, just to sit down informally and chat. That would or would not be a violation, and I mentioned to you that the mayor could have coffee with 2 or 3 others and have it on a rotating basis just to see what's up, what's going on in their life. What's any ideas they have? If the dialogue isn't always set on a specific subject, is that violating? Because it seems to me to get a group together as a team, you need more dialogue other than just strictly business. And it's hard to operate in an informal setting if we're only limited to 3 people, and it's limited by the mayor and what he can discuss and what he can't discuss. We used to have meetings, not meetings, we used to have a social hour after the city council years ago when I was on. We'd all go out to McDonald's afterwards, and Ole Reynolds was the mayor, and he said the #1 thing is we don't discuss business. It was just a social gathering. Well, that had to end because it looked, or perception was that it was an open meeting law, or a violation of open meeting law, and that can't go on. So as far as socializing, with the council as a group in an informal setting, it sounds like it just can't be done. Am I right or wrong?
It's very difficult.
Yeah.
In your example, if there is one meeting that takes place between 4 members or fewer of the city council, excuse me, that meeting in itself is not a violation of the open meeting law. What is problematic is if, under your example, this is not one meeting, it's a series of meetings, it sure could become a violation. The second you get that 5th council member involved, or the mayor involved with the 4 council members, such that there's a quorum that has been involved in any of these meetings, it's an issue. Now, if they were on completely independent subjects, this would play into the analysis, but I would recommend not setting up a formal procedure of routine meetings among different factions of the city council and rotating it through. It raises the issue unnecessarily, I think.
And it would or wouldn't change if staff was involved in these meetings?
That would not change. It's just a matter of whether a quorum of the public body was involved.
Thank you.
I noted before that while the general presumption is any meeting of a quorum of a public body has to be open, there are obviously specific situations where the legislature has determined that there are other interests that take priority over openness in government as it relates to specific matters. They do require notice just as any open meeting would. Whatever the type of notice required for the corresponding open meeting must be given for a closed meeting as well, so that the public knows that a meeting is taking place, but they are allowed to be closed to the public. In order to close a meeting, there are specific requirements that the public body has to follow in order to comply with the open meeting law. You need to make a statement on the record, and you need to have a cite to the specific statutory authority that allows the meeting to be closed. If it's because it's a matter of attorney-client privilege, you cite to the statute that allows meetings to be closed on grounds of attorney-client privilege. If it's to discuss labor negotiations, you cite to that specific subdivision of the statute. The other thing that has to happen is you have to have a general description of what the subject matter is to be discussed. If it's a closed meeting under the attorney-client privilege to discuss litigation strategy, you'd need to identify what the litigation is, the case name if you have it, just so the public is aware that there is a meeting taking place, even though they're not going to be allowed to observe. There's recording requirements that I think will be handled generally at the staff level. I don't know that you need to be too aware of that, but just know that most meetings, when they're closed to the public, will need to be recorded. The exception to that is if it's an attorney-client privilege discussion, in which case it can't be.
Mr. Scott?
Yes.
If I may, Mr.
Go right ahead.
Who decides, could you go back one slide?
Certainly. Is that it?
Yes, there it is. The second dot down there. All closed meetings except those closed by attorney-client privilege. Who decides that it's attorney-client privilege? I mean, if two council members call you and say we need to discuss something, is that attorney-client privilege?
Any discussions I have with members of the governing body, I would view as privileged, meaning that if someone were to ask you what was discussed, I'd say that was privileged, and it's not a matter of, I mean, that's not, if it's if it's a conversation with 2 or 4 or fewer members of the city council, it's not going to be a problem anyway, because it's not subject to the open meeting law. If there's an issue that I need to communicate to you, basically it involves litigation. If I need to communicate with you in a closed session under the attorney-client privilege.
You meaning me only or the entire council?
Sorry. You meaning collectively the governing body.
Okay.
We'll go through the procedure to close it. Now, the city generally is not required to meet in a closed session. I would always take that step to protect the privilege, because the privilege is for the benefit of the city council. It's not for my benefit ever. There are certain matters such as litigation strategy that the legislature has decided city councils need to be able to meet in closed sessions to discuss those issues candidly outside of the public eye, where their interests are served by and the attorney-client relationship is promoted by that being in a closed meeting. So
I get the gist of it. Also, labor negotiations, is that something that needs to be recorded too, 2 to 8 years and kept? If you're negotiating contracts, is that something?
Yes, if a meeting is closed to discuss labor negotiations, that would need to be recorded.
Okay. Another question. We have a committee meeting, 4 committee members there. They discuss the items on the agenda, motions are made and passed. They go outside, to close the meeting, go outside the door. Can the 4 of them talk about something in that meeting? Can they say, why did you do this? Why did you vote that way? Or, 4 of them. It's not a quorum.
Procedurally, how would they leave the meeting?
Well, it's adjourned.
Okay, the meeting ends.
Yeah,
4
it's
people go
adjourned.
outside.
Yeah, and they're going outside, they're going on their way.
If that is the extent of it, and the conversation does not expand to involve a quorum, it's not a meeting, so it's not subject to the open meeting law. Our general advice is to steer away from that kind of conversation just so it doesn't escalate to that level, but it's limited to 4 members.
But it isn't violating anything.
That's right. If it's
Okay.
4 members or fewer, it doesn't.
Thank you.
Mr. Scott, another question on that slide as well. The specific statutory authority to close a meeting other than attorney-client privilege, what are some of those examples where you could...
We'll get to that. Actually, I think is that the next slide. Yes. There are some meetings that if you're going to discuss certain information, the law requires that it be done in private, that it be done and be closed to the public. There's other meetings where it's an option for the city to close the meeting, but it's not necessarily required. Some of these examples, I mentioned attorney-client privilege already. If the council is considering allegations or charges of misconduct against a city employee, subject to the council's supervisory authority, that has to be closed to the public. The information that you'll be receiving and discussing, presumably, is information that is confidential, and it can't be publicized. The exception is I believe it's the case that the subject of that allegation could demand that it be in an open session. But absent that, it would have to be done in a closed session. There's certain health data, public data, law enforcement data. If it's going to be discussed, it needs to be discussed in a closed session. Medical records, I'm not sure. I haven't seen, to be honest, many examples where that kind of information has been discussed by a city council, but if it ever were, it would need to be closed. Anytime the council is going to be considering, for whatever reason, something on an especially sensitive matter, like criminal sexual conduct, domestic violence, maltreatment, the data regarding the identity of the victims or the reporters of those incidents is confidential, and that discussion would have to happen in a closed session. Active criminal investigations, law enforcement officer misconduct. Those are some examples when you would absolutely have to have that discussion in a closed session. These are examples where you have the discretion to close it. For labor negotiations, certainly have that ability, but I don't know that it's required that it be done in a closed session. Employee performance evaluations, that one actually maybe should be on the other slide. And the statute is listed as permissive, that the city council may close the meeting, but it's really up to the discretion of the employee to be evaluated. The employee has the ability to demand that it be in an open meeting, and if that demand is not made, then it really should be done in a closed meeting. You have the ability to close a meeting to review appraisals for upcoming property acquisitions, to establish an asking price for property that the city is going to sell, to develop or consider offers or counter offers if you're negotiating to purchase property, and then a few other matters on the slide there. I mentioned attorney-client privilege. There are a few examples, and none are coming to mind right now, but of statute where they, outside of the confines of the open meeting law, where they've allowed city councils to discuss something in a closed session, but those, in my experience, occur very rarely. Some other issues that come up is the open meeting law. Notices. I mentioned one of the 2 basic functions of the open meeting law is to require meetings to be noticed properly. The easiest way for that is for regular meetings. You just have a schedule of when you meet. As long as you meet when the schedule says you're going to meet. There's no additional notice requirements. Continued meetings, essentially, I think that question arose in the work session before. Basically, a meeting that's continued is the same meeting. It doesn't need special notice requirements. Special meetings, anytime you're going to meet at a time that's not on your schedule of regular meetings, that's a special meeting, requires typically 3 days' notice. That means there could be lead time involved with getting, if it's going to be published in the newspaper, with publishing it in time. So that doesn't mean you can call it 3 days in advance. Sometimes it's 5, 6 days in advance, depending on the newspaper's requirements for when information is given to them. Emergency meetings, if there's a true emergency that would prevent the city council from satisfying the special meeting notice requirements of 3 days, you do have the ability to call an emergency meeting. That power should be used very judiciously and only in true emergencies. Other issues that come up are what forums can the city council meet in? Can you have a teleconference meeting, for example? As it stands right now, there's only 2 forums that are permitted. One is in person, as you are right now. The other is by interactive television, if it's properly noticed and the city council votes to allow one or more of its members to appear at a meeting that way. There's no other electronic means by which you can hold a meeting. Some of the consequences, if there's found to be a violation of the open meeting law, there is personal liability of up to a $300 fine, and the city is not allowed to pay that on any individual council member's behalf. If a council member were to rack up 3 intentional violations, it would result in the forfeiture of office. Reasonable costs, disbursements, and attorney's fees can be awarded against the city up to $13,000. Generally, if there is a violation that would not result in the action that was taken being invalidated, at least there have been no cases that I'm aware of that have reached that conclusion. But really what we're talking about is the biggest consequences are the bad public relations that result if there's an open meeting law violation and losing the trust of the public. These are, when violations occur, they're covered. You know, your newspaper will run a story on it. The public will be aware of it, and sometimes that in itself can do more harm to the city than any of these specific consequences I spelled out. Regarding data practices, we're talking about that in just a second here, but know that the laws interact a little bit uniquely. There can be some situations where there's data that is not public data under the Data Practices Act, but nevertheless is discussed at a city council meeting. There's a provision in the open meeting law that where it's necessary to conduct public business, and there are no specific provisions in the open meeting law that allow the meeting to be closed, the city council can discuss not public data under the Data Practices Act. That does not change the status of that data under the Data Practices Act. So if it's defined as non-public and it came up at a city council meeting and you were able to discuss it, that doesn't mean that from then on that data is public. It actually still has to be protected as if that discussion never took place. It seems a bit vague, I'm sure. The most concrete example I can come up with is there's a allegation of misconduct against a city employee, and it rises to the level where termination is required. The termination, you can't vote in a closed session, so the termination has to take place in open session. But all data associated with the allegation against that city employee remains private, confidential. It can't be disclosed publicly. Typically, that would mean you can't say anything about it other than to acknowledge the fact that that complaint has been made, as you'll see in a few minutes when we talk about the Data Practices Act. But you have to take action in a public meeting, so if a termination is taken, that's related to the allegation of misconduct. So going forward, even though you took that action in a public meeting, probably advisable not to publicize further the fact that an individual that had a complaint made against him or her was terminated. If a member of the public wanted and looked at the minutes, they would see what the result of what the final action taken by the city council was, but until all appeal rights and if it's in the union setting, arbitrations had been resolved, that really shouldn't be publicized that the individual had been terminated. So the Data Practices Act serves, as I mentioned, a similar purpose to the open meeting law, where the open meeting law required meetings be conducted in the public. The Data Practices Act establishes a presumption that any data, any information in the city's possession or the possession of any individual officers and employees that pertains to the city's business is public. There are numerous exceptions to that, but that's the general rule. Unless you can find something in the statute that says otherwise, if it's city data, if it relates to city government, it's public. It's one of 3 statutes that govern information that the city maintains. You have the Official Records Act, the Records Retention Statute, and the Data Practices Act. The Official Records Act essentially just requires that the city keep records of the actions of the public body. That's where your meeting minutes come into play, any contracts authorized, any expenditures made. Those are official records that are required to be kept by the statute. The Records Retention Statute generally talks about and establishes procedures for how data that the city has can be disposed of. It establishes retention schedules. It's very detailed. It's the converse to the Official Records Act, which requires records to be maintained. The Records Retention Statute talks about how long you have to keep them and what you have to do when they're no longer needed. And it's overseen by the state archives. The Data Practices Act, it doesn't require any data be maintained, and it doesn't require that any data be kept. What it talks about is that data that does exist, that is in the possession of the city or any of its officers or employees, is generally public unless a specific provision says otherwise of the Act. It also protects the right of data subjects, and it requires that any data maintained on individuals be maintained accurately, completely, currently, and securely. So the biggest question in applying the data practice, like what exactly is data? What is government data? And it means any information that's collected, created, received, maintained, distributed by any government entity, regardless of what form it's in, whether it's electronic or in paper, regardless of where it's kept, regardless of what conditions the city uses it for. Anything that relates to the city's business and exists, any information like that is government data. Where is it kept? It can be literally anywhere. If data has been created or maintained or was received as the result of the official actions of someone on the city council or as within the scope of the employment of a city employee and it pertains to the city's business, it's government data and it's generally public. And that includes if it's an email sent from an employee's or a city council member's personal email account, their business account. It doesn't matter if it pertained to city data, it's public, or excuse me, it's government data and is presumed public. Data is generally classified as either on individuals or not on individuals, and there are essentially 3 tiers of protection to data. It's presumed public. Some data is simply private if it's on individuals or non-public if it's not on individuals. That means it's not available to the general public, but is generally available to the subjects of that data. Confidential data on individuals and protected non-public data that isn't on individuals receives the most protection. That is typically not even available to the subjects of the data. It's only available to those city officers or employees that require access to that data.
Just got a question on you mentioned the email data or electronic data that's, could be on a personal email account or thing of that nature. Who is responsible to keep that data? Is it the sender of the data or the recipient of the data? And
there's generally no requirement that the data be kept. What happens is, and we'll talk about some of this in a little more detail, but if the city receives a request under the Data Practices Act, the Act sets forth the procedures that have to be followed. If the data that had been requested exists anywhere, the Government Data Practices Act sets forth how that data is classified and under what circumstances the requester is entitled to it. It doesn't, the Data Practices Act in itself does not establish a requirement that, for example, any city emails you might receive as an individual council member be kept. If you've deleted something and someone has asked for it at a later date and it doesn't exist anymore, the answer to the requester is that the data you requested does not exist.
okay.
So it would be declined.
But that's completely different than what we have in our computer use policy. No data can be erased without the approval. I believe, I don't have it in front of me, but my thoughts are, after reading the computer use policy, that information cannot be deleted. It has to be held on to and retained for so long. We might want to check into that, because the policy might be different from what you're saying.
The policy may very well be, and if you have a specific policy on that, absolutely you should follow that policy. It's not a requirement of the Data Practices Act.
Okay.
So if you receive a request and there's data that exists and it's been retained pursuant to that policy, it will need to be disclosed if it's public.
Okay, so we will, if the policy says we have to retain records and information, and then people cannot delete their file or folder or whatever.
No, you should follow the policy.
Okay, all right, that supersedes. Thank you.
As I mentioned, there's two types of requesters of data. There's members of the public, general members of the public, that have one set of rights under the Data Practices Act, and then there's data subjects. If the data is about the individual who's making the request, it is treated differently than if it were just made by a member of the public. The Data Practices Act does not require the city to answer questions. It's not a mechanism for the public to require the city to explain an issue to them. They can request data, and if it exists and it's public under the Data Practices Act, the city needs to provide it. If it does not exist, that city would refuse that request because there is no such data. The city is permitted to seek clarification of any requests, and that's actually frequently necessary to clarify exactly what time frame, for example, someone's looking for information from. If it's ambiguous about what exactly they're looking for, the city is absolutely within their rights to seek clarification of the request. It cannot request or require the requester to give any information identifying the person or to justify the request for any reason. Anyone can make a request to the government, and if you have data that's responsive, you need to address that, and if you don't, you'll need to explain that you don't. And again, this is largely handled at a staff level. I'm highlighting some of these issues so that you understand exactly how this process works and have just some familiarity with the mechanism that the Act establishes. For specific questions, you have a specific data practices policy. Your city administrator is the designated authority that is responsible for responding to requests. If any requests are made of you, you don't need to try and figure all this out. You can simply refer the requester to submit it pursuant to the city's policy.
If I may, Robert, I understand that there are some pretty severe penalties for withholding information.
There can be. If you don't mind, we'll get to that towards the end. I'm just afraid if I go up to that slide, I might not find my place back. Some data is going to be defined as not public or confidential. When that's requested, the city staff will just need to alert the requester to the statute that classifies it as such and the reason it can't be provided. Like I said, as council members, if you do get a request, just refer the requester to the city's policy and to the city's responsible authority, which is your city administrator.
Mr. Scott, speaking of that, can a constituent come to me and say he was requesting some information that's public data, and he didn't want to be, he didn't want to go to the city, so he wanted to get it through me? I mean, I'm assuming I can get it and then pass it on to him or her.
If it's public, there's nothing improper in giving it to him. As a best practice, our recommendation is always to have someone who's requesting data to go through the city's policies so that the city treats everyone equally. There are requirements, and I'll skip through some of this probably because it's not particularly relevant to city council members, but there's requirements for, or the city has the ability to charge for the reproduction costs of the data. It would be, in an ideal situation, everyone would follow the same procedures and policy, and it also provides a level of protection to the city if there's a request for information that is of a more sensitive nature, and it is more important that they follow the city's policy and that they make the request in writing. It helps to be able to say that everyone who seeks data from us has to go through this procedure. So my advice, my recommendation, if you are approached by someone who wants to make a request of you as an individual council member, would be to refer them to the city's policy.
And then another item, the police department, sheriff's department, county and city, all that's public data except for maybe names or, but if somebody requested how much marijuana is confiscated, last year, is that public information? Is that public data? I mean, they'd have a record of it.
It may be. It would depend what the record is and what other information might be kept on that record.
Well, this wouldn't be an individual. This would be just a total. How much marijuana was confiscated in 2012 in the city of Willmar? Public data?
Possibly. I mean, it probably is. But the reason we have a policy also is so that we can look at these individuals. I mean, this is a very complicated statute. As attorneys that deal with this, weekly, we rarely are able to answer a question without actually going to the statute and looking it up. So,
okay,
probably it's public, but we would want to go through the process. These are issues that your staff will be aware of and will need to, and I'm sure does, address. Some of the issues when they receive a request is it a request actually for data? Are they seeking some information or something that the city does not actually have? Is it for government data? How was it classified? Was it made to the correct person? Did they follow our policy? These are all initial inquiries that staff would make and would make. If you receive any inquiries and refer them to staff, this will be how the staff will approach it. As far as the timelines for responding, they typically aren't concrete number of days, except if it's requested by a data subject. If the data is public, it needs to be provided within a reasonable time. If it's not public, it can't be released unless it's to the subject of the data. And if it's confidential, it generally can't be released at all. If it does not exist, a simple explanation that no such data exists is appropriate to deny the request. I've talked about some of this already. Other issues that come up, and again, are dealt with primarily on a staff level. If someone is being asked to submit data on themselves as individuals, there's typically warnings that need to be, and notices that need to be provided to the person. Tennyson warning comes before the information is provided and just alerts the person to what the uses of the data will be. If the use of the data will ever change, or if someone is requesting that this, or if the subject of the data is requesting that otherwise private data be disclosed to some third party, you would need to get informed consent from that person. And again, that would be mostly at the staff level. This slide addresses briefly some of the authority the city has to charge requesters for the cost of making the copies and of the copies themselves. I don't think is particularly relevant to the city council. This is the part that I think if you can just have some general awareness when you see this kind of data, and if it's coming from our office, we'll do our best to highlight if it's not public and needs to be protected. But if you're dealing with issues associated with labor relations information, that generally it's generally not going to be public, and you'll need to protect the confidentiality of that data. Same thing with Social Security numbers of any individuals. Security information, meaning details of how a specific building is set up for security, things like that, that is generally not public. Any trade secret data that might come before you, generally, again, not public. And probably the single biggest issue to take note of, if you have a situation where you have personnel data, and there will be, whether it's a performance evaluation or if allegation of misconduct rises to the level where it needs to come to the city council, this is generally not public. Most data is presumed public. For personnel data, the presumption is flipped. Unless there's something specifically in statute that makes it public, it's going to be either not public or confidential and should not be disclosed. And really, for personnel data, no matter what it is, whether it's simple, whether someone's name or position that the act actually does make public, there's really no reason for the council members to ever need to disclose that. That can be addressed to staff. So when you have personnel data, protect its confidentiality. On a similar vein, applicant data, individuals that are applying to the city for appointments or for positions of employment, if it ever comes before you, is generally not public. And again, I would recommend to the city council that you never disclose that data. Those requests can be addressed with at the staff level. Some other examples of data that may come before you that is not generally public: civil investigation data. That's something that would be designated as such by my office. That would probably be pretty clearly marked as such. Privileged data, again, our office makes every effort to identify communications or other information that's privileged to you, so you know that. Law enforcement data, some other classifications. It's a comprehensive statute. The overriding message in all this is you don't need to have this all figured out on your own. Have awareness that some of the data you have is particularly sensitive, but even as just a general matter, for any information, if you're asked to disclose it publicly, I would work through your staff rather than assume that it's public and run the risk of violating it, of violating this act. If it is violated, it may subject the city to a lawsuit for damages. Any damages that can be proven as attributed to the disclosure of the not public data, including costs and reasonable attorney's fees. Exemplary damages, also known as punitive damages, can be assessed as well in a minimum amount of $1,000 up to $15,000, depending on the nature of the violation. Courts can issue an injunction to prevent future disclosures of the information, and there could be litigation just to compel compliance with the act in the future. If there's, that would be more in the nature if there's public information that is not being disclosed. Any person, whether it's a city employee or an elected official that does and is proven to have willfully and knowingly violated the Data Practices Act, is also, on top of those civil remedies, guilty of a criminal misdemeanor. So this is something just to be aware of and to be careful with and think about if you have information or if someone has requested that you provide information that really should go through city staff. And that is the presentation on the Open Meeting Law and the Data Practices Act. Are there any additional questions right now?
Councilman Christensen.
Thank you, Mr. Mayor, and thank you for your presentation. Very thorough, and appreciate it. How was the MUC and hospital under the Public Data Act? Is that, since they're owned wholly by the city, can somebody request, go to the MUC and request whatever records from the windmills to electricity or public data?
Generally, they are subject to the Data Practices Act. Anyone can make a request of them, and that request would have to be evaluated. There are specific provisions within the Data Practices Act that would apply uniquely to each entity, I think, and would tend to make certain data that they have more routinely not public, but it would have to be handled the same way as if the requests were made of the city. I believe they should have their own procedure for responding to requests.
Yes.
Yes, I believe both of them do.
Who evaluates whether the request is valid or not? I mean, is the hospital board, the MUC board, or is it the city attorney? Or
I can't speak for the hospital or the MUC. I'm not sure what their policies require. In the city's case, the responsible authority is the city administrator, so she would be the one to evaluate the requests, to insist that the policy be followed. If there's, as it's inevitable sometimes, if it's not a clear-cut interpretation, she's always free to consult our office.
And typically we do, if we have a question about it. The most, I guess the example I gave is during the, when there was the investigation with the MUC, we received, and I think the MUC also received a number of data practices requests, and in both of those we worked with the city attorney as well as the League of Minnesota Cities Attorneys before information was released to ensure that it was appropriate for it to be released.
how about other entities at the hospital, Rice Home Medical, Rice Care Center, any other partnerships that they have? Are they also then fall under the public data?
In the case of the corporations formed by the hospital, I honestly don't know.
Keep in mind that the hospital is wholly owned by us.
The hospital is, and certainly the hospital board is subject to the Data Practices Act. Whether the corporations that have been created by it are also subject to it, I honestly don't know. I assume that would be addressed in statute. If it's not expressly made subject to the act, it probably isn't.
Okay, thank you.
I can certainly look into it and get you an answer, Councilmember Christensen.
Mr. Mayor.
Go ahead, Councilman.
Regarding Rice and the MUC, we're bound to be open in our dealings with our committee structures and what's going to be discussed. Does that also apply to the subcommittee meetings of or the committee meetings of the two entities, Rice Hospital and MUC? Are those supposed to be public meetings?
I'm not sure how the hospital's committees are established and what their characteristics are, so I can't speak to those. Regarding the utilities, I am more familiar with how those are set up, and those operate less as formal committees that meet regularly, and I think share more characteristics with an ad hoc committee. When an issue comes up that they need to meet on, they do. Mm-hmm. I don't believe they would be subject to the open meeting law.
Could you verify that for me and let me know?
Sure.
I'd like to know.
Sure.
Thank you.
Other questions or comments? Councilman Christensen?
Thank you, Mr. Mayor. Again, yeah, just one more thought. How long does public data have to be kept?
It's a complicated question. It depends entirely on the type of data.
I mean, we have an inspection of rental units in Willmar every so often, depending on how large the rental unit is. And records of that sort, would that have to be kept? Is there a time when you can toss it, or?
I frequently see 6 years for
Okay.
those kinds of records.
Is that same with like building inspection reports, things like that?
Generally, yes, but I don't want to commit to a specific. I mean, for every kind of record, there's probably a specific.
There's a, there,
provision,
for every
and it's
record, there's
complicated, and
a
we'd need to
different
look at
records
that.
retention requirement.
And a citizen could come to the city and say, I would like to see the building inspection report for such and such a house back in 1997. Is that?
Certainly, a citizen can always come and make that request. Whether that is actually information that the city has in its possession,
I see.
is a different question. If they do, and that would be determined by the records retention schedule and things like that. If they do have it, and it's public, they'll need to provide it.
And the policy also allows us to charge for the time it takes to research and some of those things as well, to make sure that requests are germane or that they're not excessive. So that's all set up by the city's policy and statute.
Councilman Lemon.
One other question. Calling a special meeting of the mayor and council, or any four people, it's on page 7, who can call a special meeting of the mayor or any four council members. It should be in writing with the purpose stated. Or is there any definitive obligation we have to have as far as what the reason is? I mean, what can or what we cannot call a special meeting for? Are there rules or requirements on what would be required to be a special meeting?
Not exactly. And to be clear, where that comes from, the requirement that it be called by the mayor or four members of the council, that's actually in your charter.
Right.
The requirement that the purpose of the meeting be explained, that comes from the open meeting law. When the notice of the special meeting goes out, it needs to identify the purpose of the meeting. Is there any limit on what a special meeting can be called for? No. Anything the city council can do in a regular meeting, it can generally do in a special meeting. You just have to identify what that reason is. But there's other things that would factor in. If it's an action that it can't take for another reason, that's a different story, but it's not an open meeting law issue.
Okay, thank you.
Any further questions or comments?
Just to note, I did include a brief summary of the conflicts of interest in the memo. I don't have any slides on that. That's an issue that we have discussed very recently. The City Council recently adopted a conflicts of interest policy. I included that in the memo, again, in an effort to give you a little more comprehensive reference available in the future if an issue comes up. Obviously, your policy was recently enacted, and you'll need to follow that. It applies anytime a council member has an individual personal financial interest in a matter that comes before you, whether it's contractual or not, and that would require you to, under the policy, seek guidance from the city administrator or my office. And that, again, is I think the most important point to emphasize is you don't need to figure this out on your own. The purpose of this is to just raise your awareness of some problematic issues that tend to come up more often. And you do have city staff in my office as well to help sort through any tricky issues. So.
Councilman Christensen.
Thank you, Mr. Mayor. I'm glad you brought that up. I want your opinion on recently the Hospital Board and the MUC Commission voted that they would pay dues to the Chamber. I don't know how many members on that commission or board are members of the Chamber, but is that a conflict of interest? Shouldn't they say before they vote, by the way, I'm a member of the Chamber?
I don't think that rises to a conflict of interest as it's defined in Minnesota law or even in the policy you just enacted. It's not as I understand your hypothetical, it's not a personal financial interest that an individual has. It's an association. These issues do come up, especially in small communities. It is, unless there's a specific statute that applies, it's not generally a conflict of interest just to be associated with another organization if it's not a personal there's no personal benefit to be gained that would not rise to that level.
How about an attorney that's advising a board? You know, he says, yeah, I think it's okay for the board to belong to a chamber, but not this other organization, and he belongs to the chamber. Is that a conflict of interest? It happened. I mean, this happened. This is not arbitrary.
That gets into a whole different realm, which is the rules of professional responsibility. I don't know. I don't think so, but I don't know, and I'm certainly not able to just off the cuff opine on it. So I apologize, but I just don't have it.
No problem. I just thought it was interesting.
Mr. Mayor, not to debate with you, but just a point of clarification or an example. If I belong to the Builders Association, which I do, they come before us to ask for a liquor license for after their home show. I'm a member of it. I have to abstain from voting, correct?
That's correct. So the organization that, in your hypothetical, you belong to is asking for a specific license.
Right.
Yes, that would be more of a personal interest, and you would need to abstain.
Not really a financial interest to me, but still I'd be obligated to as a council person. If you're a member of an organization that's in jeopardy of losing money through membership, in this case the chamber, if that money wasn't given to the Chamber of Commerce, let's say for this example, it could be another organization, if it wasn't given and it was voted down, that would have a financial impact on the organization that they refused to give the money to. Therefore, to make their ongoing operations the same, they would have to raise a dues membership money through their members to maintain that level of financial accountability. So directly or indirectly, if they are a member, the way I see it, if they voted for it, they are benefiting by not having increased membership dues. And if they voted against it or abstained, it would be a much clearer, transparent, and integrity type of issue that I think would be the ultimate way to go if there was a conflict. And in this case, I think there is.
I recognize the issue that you do. I think that it's not, I mean, an individual that is a member of the Chamber of Commerce in your hypothetical, if you can make the connection that their financial interests depend to some degree on the decision they're going to take, their personal interests, not just the interests of their group, then yeah, there's an issue there, and that would rise to the level of a conflict. You had asked me to compare it to an issue of some of your organization, for example, seeking a license, and it is a little different in a license application setting. I guess I won't say more than that. I think that when it's a license, it's a different analysis a little bit, so it's not quite apples to apples. For the chamber situation, for that to be a conflict such that the person who's a member can't vote and can't participate in the consideration of that issue, you need to have a demonstrated, there needs to be a demonstrated financial interest in that decision that's personal to the individual, not to the organization.
Directly or indirectly?
Correct, yes. Yep.
And that isn't a good enough example. Okay, I'll let it go. I don't completely agree with your analogy.
But it gets to the compensation. If the individual receives material benefit.
Compensation or future compensation coming out of the individual's pocket who's making the decision.
It's very case by case.
Yeah.
We'd have to look at all the circumstances.
Very good.
All right.
Thank you, Councilor, for your presentation.
Thank you, Mayor.
Are there any further questions, comments? Thank you very much. Mr. Peterson, would you like to tell us about the ordinance amending the Willmar zoning ordinance?
Mayor Yanish, members of the council, consistent with efforts to redevelop the former airport property, it is necessary at this time to move forward with some rezoning of the properties that have been released. Staff and the Planning Commission are proposing to move forward with rezoning the properties in phases 1 and phase 2 of the land release for industrial purposes, and that is consistent with our comprehensive plan. It's a recommendation of staff that the council introduce the ordinance to rezone those properties and conduct a hearing at the April 1st council meeting.
Mr. Mayor?
Sir?
I'll introduce that motion.
Second.
A motion has been made and seconded to introduce the ordinance for a hearing on the April 1st, 2013 council meeting. Is there any discussion? That's just a motion, Kevin?
Your option, as you heard tonight.
All those in favor say aye.
Aye.
Those opposed say no. That motion carries. Thank you, Bruce. We'll move right into the announcement of the council committee meeting dates. Councilman Anderson.
Finance Committee will meet Monday, the 25th at 4:45.
Councilman Christensen.
Public Works will meet Tuesday, the 26th, 4:45.
Councilman Amon.
Labor Relations, March 21st, Thursday. It's Thursday. And also, if I may, Mr. Mayor, I need to get a consensus on the performance review date, either to be by the majority of people that can be present. It's been postponed tentatively. We were going to do it this Thursday, but due to some discussions with Mr. Scott, we felt it was best to delay until a later date. And I'm just curious if we can get a consensus today for either April 10th, which is a Wednesday, or Wednesday, April 17th, where we're going to have the majority of the council present. If you can inform staff as to whether or not you're being in town, we can schedule that date accordingly.
I would encourage the council to go sooner rather than later.
What were the dates? You said the
10th?
April 10th, Wednesday, or Wednesday, April 17th. I believe that's correct. So if you could let staff know, we can send out the information. And there will be information coming on that, mail to each one of you. This, again, is highly confidential.
And that will be full councilman?
If we can, majority council, yeah, or whoever can be there. Hopefully we
Thank
can
you.
get all of us here.
And Councilman Fagerly.
Thursday, March 28th, 4:45 for community development.
Are there any other miscellaneous items that I missed? Councilman Amon?
Thank you. Thank you, Mr. Mayor. I move we have staff send council and mayor a copy of the downtown parking study.
Thank you. Can I have one?
We need a second on
We're going to have a second vote.
I have a second on that. Do we have a second? Second. The motion has been made and seconded to refresh my memory how to say that.
Councilmember Rahman, that was the presentation that was scheduled for this evening and postponed, so it will be on the next agenda and be included with that, if that would suffice.
It'd be nice to have the information prior to the meeting, because I'm sure it's pretty detailed and pretty lengthy.
We can send it out with the council meeting. We're trying to reschedule that presentation, so we will include that information when we reschedule the presentation, if that's all right.
And so that would be the motion? Do we need a motion for that?
He can put,
I'm just offering some information as to the process. I mean, that was the presentation that was scheduled for this evening, and then it was postponed due to the inclement weather.
So I don't think we need a motion.
So we will reschedule that presentation and have that information at such time as appropriate, if that's acceptable.
Okay, and I do have one comment under...
We had a call for a question. We have a motion and a second.
Motion and a second?
We have to act on that motion.
Okay. We do have a motion and a second Any discussion?
Would we read tell me what the motion is again?
Staff send council and mayor a copy of the downtown parking study.
Okay. And they already said they'd do that, but
Do we need a motion to do it, since it's on the table?
I guess since it's on the table, I guess we do have to act on it.
All those in favor say aye.
Aye.
Those opposed say no. That motion carries.
Mr. Mayor, I move we direct staff to provide sample tax abatement policies for review and consideration at the next Community Development Committee meeting.
Second.
A motion has been made and seconded, and would you read that again, Councilman?
I move we direct staff to provide sample tax abatement policies for review and consideration to the next Community Development Committee meeting.
I'm sorry, I still didn't hear that.
I move we direct staff to provide sample tax abatement policies for review and consideration to the next Community Development Committee meeting.
Thank you, now I heard it.
Councilman, did you have a question?
Is that something you're referring to the committee? Just a point of clarification, or?
The reason for this...
Motion to do that, and I'm wondering why you're bringing all these motions up under miscellaneous when you haven't declared them at the beginning of the meeting when you set the agenda.
That's a point of privilege according to
Robert's
the rules of order that we have a right to bring up at any time. So I don't think I'm procedurally wrong. I believe I can do this, and I have the right to this if the motion is made that I move the motion. And the reason for this, Councilman DeBlake, the tax abatement policy that I asked to bring up was shortly, immediately after the Lakeland Hotel project came to us before consideration, and I did not want to be embarrassed, again, not having the information or a current policy in place, which we don't have. I know it's been many months. We've had change of orders and directions with staff and consuming staff time, but before us very soon will be another issue dealing with tax abatement policy, and again, we have not done anything, and it's been 9 months, more than 9 months. So that's my reason. I think we need to act on this and get it done. It's been laying there for 9 months. Time to take it seriously.
Just for clarification, would you read that one more time, what the motion is?
I move we direct staff provide sample tax abatement policies for review and consideration to the next Community Development Committee meeting.
Thank you. And we have a motion?
In a second.
In a second. All those in favor say aye.
Aye.
Those opposed say no. That motion carries. I have one item under miscellany, and that would be that this council can submit names for the Charter Commission. We have 2 openings. And so please submit names.
I didn't hear that, Mr. Mayor.
We need to, we need to submit the names for the Charter Commission. So please submit the names that you come up with. Are there, they would be Charter Commission members, they would not be chair people or anything like that?
That's correct. They would be members of the Charter Commission, and those names would then be submitted to the district judge, and the district judge makes the appointment.
Thank you.
Mr. Mayor.
Councilman?
Do we know, has the Charter Commission submitted any names?
I don't know that for a
The
fact.
Charter Commission is not meeting until April 8th and has not done so yet, and they may show up with some names, but we are not certain.
Councilman Dockin, did you have a question?
Yeah, I did have one under miscellany, one item, if I could, please.
Okay, sure.
As you know, the Flags of Honor building was donated to the city of Willmar 12 years ago in June this year. The Joint Veterans Council recently took down the poles, and we installed new lighting that sort of shines upward at an angle. Several $1,000s were spent in doing that. We were advised that 2 have been stolen from the site, and I'm wondering if the city has an insurance policy that would cover that, and if it does, because it's their property, we gave you a key, gave Mayor Heike a key to the building. I don't know where that went to, but anyway, there are 2 missing lights that need to be replaced. If the city has a policy that would cover that, otherwise our organization will take care of it.
I don't have the answer to that, Kevin, or maybe the city administrator would have an answer to that.
The answer to that is that Flags of Honor building is listed and contents are there, but keep in mind we have a $150,000 deductible. So if you would like those replaced, it would come out of the insurance deductible fund. Because I believe it's less than $150,000.
Yes.
Just guessing.
Okay.
Thank you.
Thank you.
Councilman
Just remind Councilmember Dockin that the Joint Veterans Council was not recommended the type of lighting to be installed out there by the utilities, and that they advised you that there was a high risk of that stuff to be stolen or damaged.
Okay.
Do I hear a motion?
Move to adjourn.
Second.
Discussion? We are adjourned.